Good afternoon, my lord.
Yes.
My lord.
Milord, may I mention a case from list, Milord?
Yes.
Number 51, Milord. In this case, the petitioner has been died, Milord. So this case has become infructuous. Serial number 51, Criminal Revision 1068/2019.
Criminal Revision 1068 of 2019. Next, Mr. Ranjan Kumar submits that the petitioner is dead. Full stop. Next, considering his submission, this revision has stands abated due to the death of him. So,
Lordship, may I mention a list, case list,
yes,
serial number 15, 16, 17 and 18.
Yes.
Prayer for Passover for today because my senior A.K. Rashidi is in the
Okay.
marriage
okay.
of her daughter.
It has been submitted. There's the daughter of arguing counsel, daughter of the arguing counsel of
A.K.
A.K. Rashidi. His marriage is to be solemnized. So the learned counsel is not in Ranchi. He's not here.
No, he is in Ranchi, but he is unable to.
He is busy in the functions. Full stop. This case is adjourned for 2 weeks.
Yes, Your Lordship.
2 weeks.
Most of them.
Yes. Any more?
With consent of all the parties, one batch matter praying for next Friday only,
Which batch matter?
24 to 32, Four matters, I will be appearing, with the senior counsel, Mr. Ganguly, next Friday, we will be joining, I have taken a consent from Mr. Andri Sinha, Mr. Sumit Golodia, and Mr. Meera.
What are these matters?
Arising from the RRDA matter, in case one cognizance is caused, in the main accused, and we were the officers, alleged to be assisting in the sanctioning of the map, and his matter is affirmed up to the Honorable Supreme Court, Next Friday,
Serial number?
The serial number 24 to 32, my lords.
Next Friday means?
Next Friday,
18th.
Yes, my lord.
Okay. 24 to
24 to 32nd, my lord.
32. You have taken consent of both the sides?
Yes, my lords. All the petitioner, my lords, all the intervener, my lords, I have not taken, my lords. Intervention तो उनका पहले भी रिजेक्ट हो चुका है हुजूर.
Who are the interveners?
वो इंटरवेनर उस बिल्डिंग के रेजिडेंट थे, my lords. In one case, his intervention is already dismissed, my lord.
Okay. Adjourned
Next Friday, my lords.
next Friday. Or adjourned for adjourned, not today only.
हाँ ठीक है, my lords. हाँ ठीक deeply obliged, my lords.
Yes.
Item number 6, Lordship, some defect, Lordship. There's a item number 6, Lordship. CRMP number, please. Mr. Anil Kumar, learned counsel, Lordship, out of objection, Lordship. So in
Let
this,
the matters be called out. Defect matters don't take any time.
yes, Lordship. Obliged.
Any other on the list?
On daily call days, under the heading order final disclosure matter related to stay of lower court proceedings, serial number 1, criminal division 1045 of 40, with serial number 2, criminal division 1052 of 14.
Milord, on the last occasion, Milord has directed the counsel for the ACB to verify the facts, Milord, whether the case is covered by, we have referred to one case, Milord. Mr. Suraj Verma, we have sent the copy of the order.
Lordship, today he is unavailable, Your Lordship, due to his personal difficulty.
Prayer has been made on behalf of Mr. Suraj Verma to adjourn this case. List this case next Friday. Full stop. The counsel for the ACB will comply the direction dated 3/12/2021.
Milord, we are praying that I have not sent the order to your lordship through the email because it's need prior permission. So I may send the same through the email, my lord.
Send it through the email.
My lord. And there is interim protection, my lord. Obliged, my lord.
Under the heading Order with Defect, serial number 3, CRMP number 4110 of 19.
Your Lordship, in the instant case, I am appearing on behalf of the petitioner. In the instant case, there is a defect in relation to filing of certificate.
What is the CRMP for?
CRMP for restoration, Your Lordship.
Restoration of?
Restoration of CRMP number 1558 of 18, Your Lordship.
See, what is the defect? Let's see.
Defect is in relation to filing of certified copy of order dated 17/9/19, the preemptive order and non-compliance of the same. This the same has been dismissed, Lordship. But Your Lordship, there is difficulty in this case. I had applied for certified copy on 9th of January 2020 itself.
Then why it was not handed over to you?
But till date, it is not being handed over to me, Your Lordship.
Peremptory order was not complied with.
Your Lordship, एक supplementary affidavit file करना था. Although I had filed, but due to mistake, number has been wrongly mentioned as 1558 of 19, and due to the same has been dismissed, Lordship.
This application has been filed, defects ignored. This application has been filed for restoring CRMP number so and so, which was dismissed for non-compliance of the peremptory order. Next paragraph. Learned counsel for the petitioner submits that he will remove the defects and says that due to inadvertence and situations beyond control, he could not remove the defect within time. So stop. Considering the efforts, he begs for apology. For considering the aforesaid facts, his submission, this CRMP is allowed, CRMP number so and so is restored to its original file. Rest of the defect in the CRMP should be removed within 2 weeks.
Obliged, Lordship.
Obliged.
Serial number 4, CRMP number 4111 of 19, Mr. B. N. Prasad, for the petitioner.
No one appears. 4 weeks to remove the defect.
Serial number 5, CRMP number 4277 of 19, Mr. Shobhakar Mishra.
No one appears. 4 weeks to remove the defect.
Let's state time.
Give us a step. No one appears on behalf of the petitioner.
Serial number 6, CRMP number 1036 of 20, Mr. Anil Kumar Jha.
Lordship, the personal difficulty to consign lawyers, so Lordship,
What is the defect?
defect.
Anis Khan. Who is Mr. Anis Khan? Who is Mr.
Lord-
Anis?
Mr. Anil Jha is personal.
Serial number.
Yes, sir, Lordship.
Serial number 7, my lord. CRP 1106 oblique 20, my lord.
Serial number 6. Just a minute. Wrong has been handed over.
Lordship, item number 6, Lordship.
Item number 6. 6.
Mr. Anil Kumar Jha is to suffer cough and Lordship.
So this is for restoration. You can assess this court if you are his.
Especially restoration, Lordship.
Why this case was dismissed?
Lordship, not compliance to orders, Lordship. Some document.
On the request of the counsel for the petitioner, this case is adjourned for 2 weeks.
Obliged, Lordship.
This application is being filed for restoration of the criminal revision number 11518 which has been dismissed for default on 27/2/2000 for non-compliance of the order dated 19/2/2020 passed by your lordship, my lord. The reason is done in paragraph 5, my lord. So reasonable time may be given so that I can remove the defect, my lord.
Sit down. CRMP allowed. The original criminal revision is restored to its original file.
How many times, my lord?
3 weeks time to remove the defect in the main. क्या था?
I am not audible, my lord.
Two weeks time.
3 weeks कर दिया जाए, my lord. 3 weeks कर दिया.
3 weeks.
Okay, obliged, my lord.
Serial number 8, CRMP number 1303 of 20, Mr. Ashutosh Anand, Mr. Vinay Chandra.
Lordship, in this case, there are 4 defects that, if your lordships may please, it may be ignored, my lord. As it is with respect to the provision of law which is missing in the application portion, my lord, the first portion.
No, why it was, which case was dismissed? Criminal revision.
Division, my lord.
Why it was dismissed? You have not removed the defect.
My lord, the first court copy was not there, my lord, certified copy. So
Then
that was to
why
be procured.
3
My lord?
weeks. 3 weeks.
Yes, yes, my lord.
Restored. Same order.
Very much obliged.
I am for the state in this case, Lordship.
Give your slip. Give your appearance slip.
Okay.
Serial number 9, CRMP number 1598 of 20, Mr. Arvind Kumar.
My lord, my file has been misplaced, my lord. I don't know about the case. Next week, my lord, I will do it.
Two, 3 weeks to remove the defect.
Yeah.
Serial number 10, CRMP number 1989 of 20, Mr. Mohammed Kaisar Alam.
May I please, my lord? This case has been filed for the restoration of, my lord, criminal revision 51531 of 2018, my lord. That has been dismissed for default for the non-compliance of order dated 19/2/2020.
Within how much time? Within 3 weeks you will comply, you will remove the defects?
That the certified copy has been filed, my lord. On that has been received after the due date that has been given by the lordship 19/2/2020, and that has been filed on 27/2/2020.
After the petitioner submits that he has already removed the defect in criminal revision 1531 of 2018. Full stop. He submits that the state case was dismissed for non-compliance of the peremptory order. Full stop. Next paragraph. Since the order has been complied with, though after the date fixed by the court, period fixed by the court, I'm inclined to allow this application. CRMP allowed, criminal revision restored.
Obliged, my lord. Much obliged.
Defects ignored.
Serial number 11, CRMP number 2093 of 20, Mr. Jitesh Kumar.
Yes, my lord. I may be permitted to withdraw this application, my lord.
Permission to withdraw, dismissed as withdrawn.
Much obliged.
My appearance, my lord.
Give you a slip.
Serial number 12, CRMP number 316 of 21, Mr. Mohammed Asadul Haq.
मैं appear 3 weeks time are granted. For restoration of CRMP number 2802 of 2012.
3 weeks to remove the defects.
Yes, madam.
Serial number 13, CRMP number 891 of 21, Mr. Ajay Kumar Pathak.
Lord, I have a claim. Lord, this is for restoration, Lord, of CRMP, Lord, 3611/2020.
Defects. What are the defects? Affidavit older than 21 days.
Lord, this is for restoration, Lord.
Defects to be removed within 3 weeks.
Serial number 14, BA number 10856 of 21.
Yes. Yes, who is appearing?
No, I'm for the state, no.
None appears on behalf of the petitioner. Will stop. The defects should be removed within 2 weeks.
Under the heading fresh filing admission, serial number 19, ABA number 1055 of 21, Mr. Tarun Kumar, number 1 for the petitioner.
Well, the offence under section 79 of Juvenile Justice Act, the case of petitioner is earlier rejected by your lordship by the order dated lordship 16/9/2020 lordship. Thereafter, lordship, the petitioner has moved before this honorable court in CRMP number 1607 of 2021. Same has also been withdrawn. But my lord, the fresh ground is that lordship, the father, guardian of the children have filed the application before the court below through their lawyer. They have stated, lordship, their children were not working in the hotel of the petitioner, lordship. Only this is the fresh ground, lordship.
The anticipated bail of this petitioner was earlier rejected on 18/11 on
16/9/2020, lordship.
16/9/2020. What is the fresh ground?
The guardian of the children have filed the petition before the court below, lordship. Their children were not working in the hotel of the petitioner as a child labor, lordship.
They filed an
That is
evidence.
annexed 2. Annexed 2, lordship. I have annexed the petition along with the affidavit of the parents.
Mr. Counsel, it will come in the order that you have tampered with the evidence.
Then, my lord, I may be permitted to withdraw this case with liberty to this petitioner will surrender before the court below. And
who is taking away this liberty? Because the counsel for the petitioner seeks permission to withdraw this application. Dismiss as withdrawn.
only I am paying, lordship, the direction may be given to the court below to dispose of the bail application.
So, Mr. Counsel, what sort of submission you are making? Why do you need a direction to the court below for disposing of the bail application? You will file it, will be disposed. Yes.
Serial number 20, BA number 14301 of 21, Mr. Tarun Kumar Mahato.
Yes. Yes.
And the prosecution witnesses have been examined so far out of 14. And after the last rejection, no fresh, no new witnesses have been examined.
So if there's a direct allegation against you. There's a direct allegation.
Co-accused have been enlarged on bail. And if my lord may kindly see the FIR.
Yes.
The same allegations, my lord. If I can draw your lordship's attention towards the middle, my lords.
Yes. You are in custody since when?
Vicky Pandey, Kana Karanji.
You are in custody since when?
17, my lords.
17. How many witnesses?
Yes, only 3 witnesses have been examined. Even the last time when
how many examined?
For bail.
How many examined?
3.
7 left.
3.
7 left.
Or 11. No, total my lords, 14 prosecution charge sheet witnesses.
Ten witnesses in the charge sheet who are yet to be examined?
11 witnesses.
Yes, who is for the state?
Lordship, I am for the state in this case, Lordship, and moreover, Lordship, the impugn order, Lordship, he have not, after rejection of this honorable court on 5/6/2020, Lordship, he have not moved before this court below. Again, he has challenged the same impugn order, and he have.
He has not challenged the same impugn order. He is praying for bail. Just tell me one thing.
That is their Lordship, but the procedure is that, Lordship, after rejection, Lordship, we have to move before that court, Lordship.
Where is the procedure? Show me. Show me.
Lordship, just now I have not.
Show me the rules.
Yeah, Lordship.
Show me the rules whether he has to move before the court below.
Lordship, next week, Lordship, I will show the rules, Lordship. Let it be next week, Lordship.
I'm keeping this case on next week.
Yes.
You just listen to me. You just seek instruction and tell me that you have to produce how many witnesses, number one, and these witnesses to be produced on each and every day, and their statement should be recorded within 15 days. 7 witness, 15 days, finish the trial. Let's discuss next week on the request of the counsel for the state.
लॉर्डशिप आइटम नंबर 7 में नेट प्रॉब्लम के चलते लॉर्डशिप हम कनेक्ट नहीं हो सके थे लॉर्डशिप आई एम फॉर द स्टेट लॉर्डशिप
Remove the defect.
लॉर्डशिप
Yes, next.
Item number 19, Lordship. I could not attend. Net problem, Lordship. 19.
Under the heading for admission, serial number 21, CRMP number 1470.
Item number 19 disposed of. He's withdrawn it. Yes, give us a
I've also not heard the whole Lordship, because there is something net problem, Lordship, network problem, Lordship. I've also not heard whole order, Lordship.
You just seek instruction and instruct them. I have not passed. It is on Friday. You just seek instruction. You'll have 10 witnesses left. All of them should be examined within 2 weeks.
Okay, Lordship.
Tell the prosecution to produce. It will be next week. Yes. Next.
Under the heading for admission, serial number 21, CRMP number 147015, Mr. Rajesh Sahaya, Mr. Arun Kumar Sinha.
Yes. In view of the order dated 4/12/2020, this case should be listed on a date when the court hears cases, physically. In physical mode. Yes, next.
Serial number 22, CRMP number 1375 of 16, Mr. Ashish Kumar, Mr. Rakesh Kumar.
Yes, my lord, I am appearing in this case.
Yes.
My lord has called for the status, your lordship, on last occasion.
Yes. Who is for the opposite party?
Yes, Lordship. Today I am appearing, Your Lordship. Suraj. This is a case of Suraj Verma.
Yes, what is your prayer?
The prayer is for quashing of the convenience order, Your Lordship.
Your other accused persons have filed a discharge petition.
Yes, my lord.
Go and file a discharge petition. What is your read the FIR?
Starts from page number 44, Your Lordship.
Yes.
उपरोक्त प्रसंग एवं विषय के संबंध में निवेदन करते हुए कहना है कि निगरानी थाना पीई संख्या 5/2001 का जांच कर जॉन किली पुलिस निरीक्षक निगरानी ब्यूरो झारखंड रांची के द्वारा एक जांच प्रतिवेदन दिनांक 15/10/9 को समर्पित किया गया था। संलग्न जांच प्रतिवेदन एवं संचिका में उपलब्ध साक्ष्यों के आधार पर आदेशानुसार मैं अपना प्रतिवेदन समर्पित करता हूँ। उपरोक्त जांच से श्री कृष्ण मुरारी दुबे, पिता स्वर्गीय गौरी दुबे, साकिन जिला देवघर, संप्रति महामंत्री जिला प्राथमिकी शिक्षक संघ देवघर का उपायुक्त देवघर को संबोधित पत्रांक 14 दिनांक 11/7/2000, 23 दिनांक 25/9/2000 एवं शिक्षा आयुक्त से सचिव बिहार पटना को संबोधित पत्रांक 19 दिनांक 8/8/2020 तथा श्री SS तिवारी प्रभारी पदाधिकारी जिला विकास शाखा देवघर का मई 1994 में उपायुक्त देवघर को प्रेषित पत्र के आधार पर श्री दुबे द्वारा माननीय उच्च न्यायालय झारखंड
Page 45, serial number 2 is the allegation against you.
Yes, madam.
That you have connived and you have passed orders with connivance.
My submission is, Your Lordship, that these all allegations, my lord, it were already inquired by the Honorable Lokayukt of Bihar, Your Lordship, and from there, my lord, I was given clean sheet, Your Lordship.
No.
If my lord may kindly come to the order of this Honorable Court, Your Lordship, that has been passed in CWJC number, my lord. There was no direction to lodge the FIR.
May not be. An FIR can be lodged without any direction if a cognizable offense is made out.
और लास्ट मैं सबमिशन सिर्फ सुन लिया जाता हूँ इसमें। उसके बाद इसमें जो टोटल 4 आयु इस केस का जांच किए हुए, पहले के 3 आयु जो हम केस को फॉल्स पाए थे, सब्सिक्वेंटली जो लास्ट आयु वो चार्जशीट दे दी इसमें।
Charge sheet has been submitted and thereafter court has taken cognizance.
That is, yes.
Are the counsel for the petitioner or the counsel for the state? In this case, the petitioner has challenged the order by which cognizance of offense has been taken on 6/2/2016. Yes.
एक बार सिर्फ ऑनरेबल लोकायुक्त का ऑर्डर देख लिया जाता है हुजूर, उसमें सेम एलिगेशंस का वहां पे इंक्वायरी
Lordship, she is involved in similar type of offense in Dumka, Your Lordship. Poonam Kumari saying, yeah, this petitioner
passed in special case number 29 of 2010, corresponding to Vigilance PS case number 29 of 2010. Full stop. The trial court has taken cognizance of offense under section 420, 406, 409, 201, 120B, 467, 468, 471, 109 of the Indian Penal Code, and section 13(2) and 13(1)(c) of the Prevention of Corruption Act.
लिबर्टी दे दिया जाए to raise all the points, my lord, at the time of hearing of that.
After some argument, learned counsel for the petitioner seeks permission to withdraw this application with the liberty to raise all the points all the points available to him by filing a discharge application. Full stop. Prayer allowed, dismissed as withdrawn with the aforesaid liberty. If any discharge application is filed, the same will be considered by the trial court by passing a reasoned order within a month from filing of such application. Any interim order stands vacated. This application stands disputed.
Serial number 23, WP Criminal 372 of 17, Mr. Sresh Gautam, Mr. Vibhuti Priya.
My lords, in this case, I am appearing for the state, my lords. My lords, this file has been entrusted to me, my lords. My lords, while the order dated 10/12/21, my lords, has not been complied, my lords. Your lordships are directed to file an affidavit to clarify whether 2 trials can be continued on the same FIR, my lords. My lords, I have received the instructions 2 days back, my lords, but they are not addressing the issues, my lord, the query of the Honorable Court, my lord. In view of that, I pray only for 1 week, my lord, so that I will address the issue, my lords. I will file an affidavit to that effect, my lords. Only 1 week as a last indulgence may be granted, my lords.
2 weeks as prayed by C3 is
My
granted to comply the earlier order. This is an interim order, Mr. Dipankar. Are you proceeding? State, are you proceeding?
Yeah.
Are you proceeding against the petitioner?
Yes, my lord. In both the trial for same set of occurrence, they are proceeding.
How can there be 2 cases? See, Hazaribagh PS case was transferred to the vigilance.
My lords.
My lord.
Should be a vigilance case. There cannot be any Hazaribagh PS case.
Yes, my lord. But in Hazaribagh PS also trial is going on, and vigilance case also the trial has been committed.
Close this case after 2 weeks.
Oblige.
And Mr. Srinu,
My lords.
instruct the client accordingly if you find that both the cases are continuing.
My lords.
Yes.
Oblige, my lords.
Serial number 33, Criminal Division 1383 of 17, Mr. Vishal Kumar.
Lords, I'll be assisting Milords in this case, Milords. Milords, on the last occasion, the vigilance was directed, the Anti-Corruption Bureau were directed to Milords submit the status report, Milords. I have also inquired from the Milords, my client also. He has said, Milords, that only one witness has been examined, Milords, Milords, after framing of the charge.
This is against discharge.
Yes. Against the discharge.
To read the order.
Milords, may kindly have a glance to Milords. Milords, may I say one thing subject to Milords' convenience?
Yes.
Milords, this is an electricity theft matter, Milords. If it is posted in any physical day, Milords, in the opening next week or something like that, Milords, we'll be in a better position to assist, Milords. Because it is a bit technical, Milords. And particularly me, Milords, I was the executive engineer, Milords. I had negligible role in the inspection, Milords, as well as the execution of the agreement, Milords. Then those were in fact, the loads were also sanctioned, Milords, by the GM level authority, Milords. That is the reason I was only praying, Milords, that the inspection report and all those things are on record, subject to Milords' convenience any day in the Milords, next week, or subject to Milords any physical day, Milords.
This you have to rely. You will be relying upon the inspection reports and all these things.
No, Milords, those are forming only on those papers, Milords, which are forming part of the police papers. I am not going beyond that, Milords. I cannot go beyond because I have a limited jurisdiction, Milords. I am conscious of that, Milords. That it's a discharge petition, Milords, where I have to be within the Milords circumference of the police papers, Milords. Any next week or subject to Milords may put it on in the physical, Milords, any day, Milords.
Mr. Rahul Kumar, as he wants this case to be heard in physical mode, this case is adjourned to be listed on a physical hearing date.
Milords.
My lord,
in the opening week when the Milords physical mode continues, Milords start, Milords.
My lord, I seek your permission before speaking anything. My lord, I'm waiting for my serial number 28 to be heard, so that I can say something in that. Serial number 28.
Who are you in 28? You represent whom?
My lord, please, madam, my lord.
You are representing whom in serial number 28?
I am serial number 28. I have filed one intervention application, and when the intervener as a party respondent, I will be in order to assist the court.
Because there is no question of intervention. They have sought for an adjournment. The case has been adjourned.
So kind of you, my lord. Thank you.
Yes.
Serial number 36, Criminal Division 1715 of 17, Mr. Sukya Madhika, Mr. Rajesh Kumar.
Yes.
36. Yes, 36. Hello, I am appearing in this matter, my lord.
Yes.
My lord, these petitioners, one of the group of petitioners, they formed a society and they are the purchasers of land. If your lordship will kindly look into one of an annexure, the order passed by this honorable court, the entire case will be, my lord.
What is this?
Discharge.
Discharge.
Yes.
Yes, which order you are referring to?
I am referring to the impugn order at 136.
No, you one order of this court you are saying?
Order of this court is one on annexure 3 at page 120.
Arising out of the same case?
Same case, same.
Who are the petitioner in that case?
He was the deputy commissioner here.
Okay.
The entire story will come up, madam, that all permissions were there and these petitioners are retired persons. They have purchased the land.
They are the purchasers.
Purchasers.
You are saying that this case is same. The case of
in the sense that this High Court has observed that everything is correct. Nothing is wrong there. There's a permission of the deputy commissioner, everything. The person who has accorded the person was the person that his case has been quashed.
No. That deputy commissioner's case was quashed that he was a judicial officer. He was performing a quasi-judicial work.
I'm coming to the fact of the 126 page, madam.
Yes.
126.
Yes.
Having heard the learned counsel appealing for the parties, last paragraph, it does appear the appellate court having set aside the order passed by the deputy commissioner under the question to transfer the land had been refused, remanded the matter for its reconsideration. The appellate court, while remanding the matter, left it open for the deputy commissioner to consider again as to whether the purpose for which the land is being sought to be transferred can be reasonable and sufficient, other than the purpose which has been stipulated under the Act. As per the order of the appellate court, the question is to be decided after taking into consideration certain factors which have been enumerated in the appellate court's order. The petitioner, after taking into consideration those factors which are required to be taken, granted permission for transfer of the land to the Housing Cooperative Society, of which we are the members. After being satisfied that the purpose for which the land has been sought to be transferred is reasonable and sufficient. Subsequently, the order has been confirmed with slight modification of the point of rate on which the land has to be sold. In spite of the the instant prosecution has been launched against petitioner on the premise the permission for transfer cannot be granted for building purposes. And the reason on which the earlier deputy commissioner had refused to grant the permission has not been taken into consideration by the petitioner. Now, this order has not been challenged by the state, but these materials cannot be argued on launching prosecution against the petitioner in absence of any material.
Let us see where is the impugned order of discharge.
Yes.
Let us see.
So it starts at 136.
136. Yes. Who is for the vigilance? Now you will argue the case for half an hour, then the vigilance council will come up and say that, and find no one is appearing. Or some will come and say that I want some time. Who is appearing for the vigilance?
Suraj Verma.
Oh.
Last occasion he has appeared.
Today in some of the cases on the ground of Mr. Suraj Verma, the time has been sought. Yes. Mrs. Shrestha?
Yes,
Secured order.
Who will argue this case?
That was an order whereby
this is serial number. Sir, क्या है serial number? Majumdar.
36.
Yes, Your Lordship, I am appearing.
36 you are appearing. Are you ready? Yes. Yes, Mr. Majumdar. Let us go through the order.
Page 137 will be relevant, my lord.
Yes.
Having heard, perused the record, and gone through the material placed by the accused prisoner with their discharge petition as well as the material collected during investigation, it is submitted that the accused Kamlakant Mishra, named in the FIR as accused number 5, he was with the secretary of the Mahabir Griha Nirman Samiti, Dhurva, Ranchi, which is a registered society having.
It is your Mahabir Mishra.
Yes, my lord.
Who are you?
22 petitioners are there, other members of the my lord. He was the secretary.
No, who are you? How many petitioners are here?
22, my lord.
22 petitioners.
Yes, my lord. All my lord, they have purchased land.
Okay. Yes. Yes, read that.
That society being registration number such and such. The allegation is that he is the secretary of such in connivance with his other members accused by hatching counsel and by influencing public servants illegally obtained permission and grab. That permission was there. That has been said, and grabbed the land of various scheduled castes Adivasi Rayas in the name of such Samiti by virtue of various registered sale deeds. It is always against him that the accused petitioner was organizer and the first secretary and subsequent secretary, Mr. Vikramaditya Singh, accused, has allotted such land to other 28 members of the society in between the period such and such to such and such. The present accused either being secretary or being members of the society has done any illegality. Rather, they are taking valid sanction from 49 of Chotnagpur Tenancy Act, got the land of Rayat transferred in the name of society by registered deed on payment of consideration to the vendors Adivasi Rayats through fixed deposit as per the order of the Deputy Commissioner, Ranchi. And none of these vendors Adivasi Rayats who sold the land to the society having any grievance, nor they appeared as the informant or witness of this case. It is some of the other accused persons are the members of the society and the case stands on a better footing. The accused Kamalakant Mishra and Mr. who are the secretary. The Deputy Commissioner and the other officials who granted permission were made accused in this case. But the entire criminal proceeding of such government servants has been quashed by various order of the Honorable High Court. Thus, the present accused prisoners have not done any illegal, constituting any offence, forgery, cheating, prevention of corruption, and there is no material on the record for framing of charge against them. It is submitted that the Honorable Court, by an order dated such and such passed in such and such, quashed the entire proceeding of the Sudhir Prashant, which I was the reading of, the Deputy Commissioner. The entire proceeding for accused Narayan Singh, the circle officer, has also been quashed by an order dated passed in such and such. The entire criminal proceeding against Naresh Kumar, another circle officer, such and such, which has been quashed by the CRP. The entire proceeding of the accused Rajesh Kumar, another circle officer, who have been quashed by such and such. It is further submitted the criminal proceeding of accused approach and the circle inspector, circle office Ranchi has been quashed, and the case of the petition stand on a better footing on such and such. In entering the discussion after that is disclosed in the district petition, but the present accused petitioner, Commissioner, others before the Honorable Court for quashing FIR, present vigilance case number for quashing of the order taking cognizance, but the same has been dismissed by Honorable Court on order dated such and such, which is on the record, which the Honorable Court in dismiss the application, petitioners have been pleased to observe such and such. Well, this was the observation.
Yes.
The accused person named in the FIR and course of investigation, the material collected in the specific case of the prosecution, that the accused persons being instrumental induced the Adivasi Rayat Mangal Tigga such and such who filed an application. They filed an application under 49. Who are the Rayats? That were Adivasi Rayats. 49, which was registered in this case number such and such, Deputy Commissioner Ranchi for permission to sell their acres of land. Their plots number such and such, Moja such and such, having registration number. Similarly, Hardgaon, Munda and 10 others also filed application miscellaneous case number such for permission to sell, transfer their land of 4 plots to Moja Hinu. However, the Deputy Commissioner Ranchi on the report of Deputy Collector Ranchi, after analyzing the law, not granted permission, rejected the petition in both the cases. In those cases, Rayat is preferred appeal. Rayat's preferred appeal. One of the Commissioner Shatnapur Division Ranchi, who has been pleased to secure the order, remanded the matter to the Deputy Commissioner Ranchi, where the matter kept in abeyance without passing any order for a long time. When the Deputy Commissioner Ranchi, by an order dated, granted permission to sell their lands to the society on payment of
yes. What do you have to say, Mr. Srisht? What do you have to say? Unmute yourself.
Yes, Lordship.
What do you have to say?
Lordship, there is no illegality in the order passed by the vigilance.
Don't argue mechanically. Just tell me, considering the fact that the person who has granted this sanction or permission, his case has been allowed and the order taking cognizance quashed. So far as all the officials are concerned, their cognizance is quashed. The permission, there was a permission granted. Was that permission revoked till date by any authority?
No, Your Lordship.
Then how can you initiate a criminal proceeding against this person? So tomorrow I pass an order in any civil case where right title and interest and possession is sought for, and I grant the relief, and tomorrow you will file a case against me.
No, Your Lordship.
What sort of criminal proceeding is this? Absolute abuse of the powers? Because of these type of cases, your executive has stopped working. I know am I making these comments consciously, knowing fully well that this entire proceeding is being live streamed. How do you justify this? Criminal proceeding? Even if the land, even it is admitted the land belongs to the scheduled tribe, there is an admission that there was an application by the Rayat seeking permission to sell. At first instance, the said applications were rejected. The Rayats moved before the appellate authority against that rejection order, which was in fact in their favor, that their land was not to be alienated in that way. They did not want that order. They wanted their land to be alienated. They filed an appeal. There was an order of remand. The deputy commissioner passes an order allowing permission. The permission order is there. Thereafter, there was a sale.
Yes, Your Lordship. That is there.
Really? Why not these poor persons who are forced to come to this court, against whom you have criminally proceeded? It's a trauma. Why not appropriate cost would be imposed upon the state? Tell me. Why not an appropriate cost should be imposed? On the facts of it. On the facts which are there in the impugned order. I'm not adding anything to it. Nor I'm trying to interpret it also. A particular fact can be interpreted in both ways. I'm interpreting in the way the court has interpreted and your officer during investigation has interpreted. This is a classic example how a criminal proceeding is being misused to target the citizens. If a land is being purchased in violation of the CNT Act, in this case, it is also not the case. There was an order.
Yes,
Where is the question of 467, 468? Which document has been forged? Tell me. (467, 468, 471). Tell me. What is 467, 468, 471? What is 467, 468, 471? Who has been cheated? Tell me. 420. Who has been cheated?
Yes, Your Lordship, that is there, Your Lordship.
Tell me, who is the person? If there's an allegation under section 420 of the IPC, a person must be cheated. 415, delivery of possession. We should not have done that act. Who is the person who has been cheated? The riots, ultimately. Now, if the riots files an application for transfer which is rejected, that means the land will remain with the riots, and riot filing an appeal, what does it mean? That they want to transfer the land? Where is the question of cheating? And 467, 468, 471? Tell me.
If the riots applied for the transfer, Your Lordship, there is no question of 467, 468 also.
Even, yes, then is it your case that the riots have not filed a case for transfer? These person have manufactured those transfer application. It is not your case.
No, no, no.
Then what is 8 of the Prevention of Corruption Act? PC Act. Section 8.
31D.
We come to the impugned order. Mr. Machukas, it's section
Yes,
8.
ma'am.
Section 8 of the PC Act. The
Yes.
court said that it is the case where the charge can be framed under section 467, 468, 471, 420,
Yes.
and under section 8 of the PC Act.
PC Act. Yes, ma'am. Page 144.
Where is the positive? Where is the remote positive evidence of bribe in your case? In the affair? So, quasi-judicial authority passes an order which doesn't suit you. You will say that officer has been bribed. Ridiculous. As an officer of the court, what is your legal argument?
Yes, Lordship, they have the riots were applied for the transfer, Your Lordship. That is why no offense is made out. No, under section 420 or 467, 468, and then section 8 of PC Act is also gone.
FIR was at the instance of?
Or he says at the instance of allocation. Vigilance, my lord. RS Chief Adhichak, Sarkari Seva, Mithilesh Kumar Singh.
No.
Nigrani
What prompted him to lodge the FIR? There must be some Fadbian or written report, written complaint by anyone. Who had complained? Who had complained?
Source to me.
Informant is Mithilesh Kumar Singh, Your Lordship.
Who is he?
DSP. Deputy SP, my lord.
DSP, Your Lordship.
On what ground he has filed this? Let me see.
रांची में भूमि घोटाले के संबंधित.
Yeah, take it down. You have nothing more to say?
My lord, the only thing, my lord, you filed an IA that wasn't allowed. Charge was framed. Thereafter, there is a stay.
Consequent, Mr. Majumdar. If this order goes, everything has to go.
No, it's obviously, but it's my duty to inform.
Yes, nothing more you have to say? Mrs. Shresht?
No, Your Lordship. No, no.
Okay. This is a classic example where this is a classic example of misuse of the process of court. Full stop. An FIR was registered against this petitioner and others under section 420, 467, 468, 469, 471, 477 A, 109, stroke 120B, stroke 201 of the Indian Penal Code, and section 13(1)D, read with 13(1)(2) of the Prevention of Corruption Act. Full stop. The said FIR was registered as Vigilance PS case number 29/2000. Next para. The allegation in the FIR is against these petitioners and other government officials. Full stop. It is alleged that piece of land was registered in favor of Mahabir Sahakari Griha Nirman Samiti. Full stop. That piece of land belongs to members of the scheduled castes. Full stop. As the scheduled castes, members of the scheduled castes were and scheduled tribes were Raya, in terms of the Chotanagpur Tenancy Act, the land, before transferring the said land, permission of the Deputy Commissioner was necessary. It is alleged that the Deputy Commissioner accorded permission under section scheduled caste, member of the scheduled caste, accorded permission and sanctioned transfer of the land, in terms of section 49 of the Chotanagpur Tenancy Act. First up. After permission was granted, the society got the sale deed registered in their favor from the Rayats who were a member of the scheduled caste. First up. In terms of the permission order, the sale amount was fixed deposited. The sale amount, the amount was deposited in fixed deposit certificate in the name of the vendors who sold the land to the society. It has been alleged that the entire transaction is against the law. With ulterior motive, the Deputy Commissioner has accorded permission, and riots have been cheated, and the entire offense, the entire transaction attracts offense of forgery, cheating, and also attracts the provision of the Prevention of Corruption Act. Full stop. Next para. After the FIR was instituted, the vigilance investigated the allegation and thereafter filed a charge sheet. As according to the vigilance, the case is true and all these petitioners and the government officials are involved in the process, which according to the vigilance attracts criminal offense. Full stop. These petitioners, who happens to be the secretaries and members of the महावीर सहकारी गृह निर्माण समिति, ये आगे भी लिखे है ना, within bracket लिखिए, herein after referred to as the समिति, approached the Special Judge ACP Ranchi by filing an application for discharge.
Can I have your lordship leave for 2 minutes, my lord?
Yes. Yes.
Can I have leave, my lord, for 2 minutes, my lord? I've been asked from the other. My junior will be there.
Yes. For discharge, full stop. Their case is that even if what has been mentioned and alleged in the FIR, no criminal offense is made out. And thus, they need to be discharged. Full stop. They need to be discharged. Full stop. The next part, the trial court, after going through the documents on record and the materials available, rejected the said application, thereby refusing to discharge these petitioners. Full stop. This order of refusal to discharge these petitioners is under challenge in this criminal revision application. Full stop. Next para. Senior counsel Mr. R.S. Majumdar, appearing on behalf of the petitioner, submits that by no stretch of imagination, any criminal offense is made out. He submits that, admittedly, the petitioners are the secretary and the members of the said Samiti who purchased the land after obtaining permission from the authority empowered to do so, under the CNT Act. He submits that the deputy commissioner who had granted the permission was also proceeded against, and so were the other government officials who had furnished their comments and had taken part in the said transfer, including the circle officer, full stop. He submit that this honorable court, in series of criminal writ applications, have quashed the criminal proceeding against the government officials by a recent order. It is submitted that those orders attain finality attained finality. It is submitted that it is further submitted that on the date the permission was granted, on the date the land was transferred in favor of the Samiti, there was a valid order of permission permitting the riots to execute cell deed in favor of the Samiti. He submits that if there was any illegality in granting the aforesaid permission, comma, the aggrieved party had the liberty to approach the higher forum, comma, as the order of permission is quasi-judicial in nature. He submits that neither the riots nor any person ever approached challenging the order of transfer. Order permitting transfer, first off. He submits that this order permitting transfer has attained finality and cannot be questioned, first off. It was further submitted that a quasi-judicial order which has been passed by a quasi-judicial authority, an order which has been passed by the quasi-judicial authority, this cannot be questioned by filing an FIR. He submits that this is nothing but an absolute abuse of the process of court, absolute abuse of the criminal process. He submits that none of the riots ever came forward to question the transfer, as the riots themselves have applied for, has sought for permission to transfer the land in favor of the Samiti. He submits that during investigation and in the FIR also, there is no element to attract. There was no element to attract Section 467, 468, 471, and 120B of the Indian Penal Code. He submits that there is nothing on record to suggest that any bribe was granted. He submits that from the facts, Section 8 of the Prevention of Corruption Act is also not attracted, as there is no evidence to suggest that bribe was given to anyone. He submits that even if an order passed by a quasi-judicial authority or a judicial authority is erroneous and is erroneous, it cannot be said that the said order was passed after payment of bribe. He submits that if these type of FIRs are filed, it will be a catastrophe. It will have a catastrophic effect and will damage the entire system. Full stop. Next para. Counsel appearing on behalf of the ACB submits that since the trial court has found that there is sufficient material, the trial court held that dismissed the discharge application and have held that charges can be framed under Section 467, 468, 471, and 420 of the Indian Penal Code. Read with 120B of the Indian Penal Code, and also under Section 8 of the Prevention of Corruption Act. On query, she submits that it is the riots who had filed an application seeking permission to transfer the land in favor of the Samiti. Next one. After hearing the counsel for the parties, I have gone through the impugned order and the materials which have been placed on record. Full stop. The fact on which the FIR has been lodged has already been mentioned in paragraph number so and so. Full stop. From the impugned order, I find that from the impugned order, a very interesting fact has surfaced, which needs to be highlighted here. Admittedly, which is being highlighted, first of all. Admittedly, the land belonged to the ryots who are scheduled caste. Full stop. The land can be transferred only after a proper permission is accorded by the Deputy Commissioner. Full stop. This is the mandate of the Chota Nagpur Tenancy Act. Full stop. The fact which surfaces from the impugned order is that the ryots themselves filed an application before the Deputy Commissioner seeking permission from him to sell the land in favor of the State Samiti. Full stop. Initially, the said application was dismissed and permission was not granted. Full stop. The ryots, that is the landholders, they themselves approached the higher authority challenging the order by which their application to transfer the land was dismissed. Full stop. This is a very glaring aspect in this case. First stop. The prosecution is trying to come up with a story that it is the ryots who have been cheated as their land was grabbed and they were grabbed. Full stop. This allegation is falsified by is negated by the act of the ryots, wherein the ryots themselves approached the appellate authority challenging the initial order of the deputy commissioner, whereby their application seeking transfer of land was rejected. Full stop. This also clearly suggests that the ryot wanted to transfer the land in favor of the Samiti. Full stop. If the intention was of the ryots were to transfer the land in favor of the Samiti, then there cannot be a question. Then this court fails to understand as to how the ryots were cheated once the land was transferred. The intention of the ryot was to transfer the land. First stop. Another glaring aspect is that the appeal of the ryots were allowed, and the Deputy Commissioner was directed by the appellate authority to reconsider the case and pass a fresh order. Full stop. Upon reconsideration, the Deputy Commissioner granted permission to the ryots to execute the sale deed and transfer the land in favor of the Samiti. Full stop. The ryots thereafter executed the sale deeds and the land were transferred in favor of the Samiti. Full stop. This fact clearly suggests These fact, which is admitted and is reflected in the impugned order itself, is enough to conclude that there is no element or there is no element of cheating in the instant case. Section 415 लिखिए. So, next paragraph. Section 420 is the punishment for cheating and dishonestly inducing delivery. Full stop. Section 415 defines cheating. Full stop. From the facts which has been narrated above, it is clear that the riots obtained permission as their intention was to sell the land, and thereafter after obtaining permission, they sold the land to the Samiti. When the riots themselves had completed all the paraphernalias, it cannot be said that the riots have been cheated. A person must be cheated so that the person who has cheated may be proceeded against. If no one is cheated, then this court fails to understand as to how a person can be proceeded for cheating. Full stop. Be it noted that the riots have never complained against this said permission order, nor complained against the execution of the sale deed. Thus, there being no element of section 415, there is no element of cheating in this entire case. Full stop. Next paragraph. So far as section 467, 468, 471 is concerned, I find that those section relates to forgery of valuable security, forgery for the purpose of cheating, and using as genuine a forged document. First up. In this case, there is no allegation that the riots have not filed any application for seeking transfer of the land, seeking permission for transferring the land, their land, full stop. It is also not a case that the transfer application was forged, or the sale deed was forged, or any documents were forged. Full stop. There is also no allegation that the permission was sought for by a person who is an imposter and not the Rayyat. Full stop. Even which are the documents, even the FIR also doesn't suggest as to which are the document which the prosecution claims to be forged. There is nothing in the impugned order also which can remotely suggest as to which are the document which is forged. Full stop. Yes, Mr. Shrestha? Which is the document? What is the document which is forged?
Lordship, no document is there, Your Lordship, forged document.
To conclude that offense under section 467, 468, 471 is attracted, at least it has to be at least it has to be mentioned or said as to which is the document which has been forged. Merely putting in the sections of the Indian Penal Code in the charge sheet without any factual basis will not attract the offenses so mentioned. Full stop. In this case, I find that merely the sections of the IPC, merely the punishable sections of the IPC has been mentioned in the FIR and also in the impugned order without applying the facts. Full stop. In a most mechanical manner, the charge sheet has been filed and in similar manner the impugned order has been passed. Even if it is held that the land were transferred in violation of some provision of law, within bracket, though it is not the instant case, as there was already an order of, already a permission to transfer, then also section 467, 468, 471 of the IPC is not attracted. As in this case, the prosecution has miserably failed to state even as to which document is forged, has been forged. Documents of security has been forged. Next. So far as Section 8 of the Prevention of Corruption Act is concerned, the same relates to bribing a public servant. There is nothing on record to suggest who has been bribed or whether any attempt has been taken to bribe someone. Full stop. From the FIR and from the impugned order, this court gathers an impression that just because the prosecution thinks that an order has been passed erroneously, there is an element of Section 8 of the Prevention of Corruption Act. This mindset of the prosecution is dangerous. Full stop. To bring home a charge under Section 8 of the Prevention of Corruption Act, it has to be specifically mentioned that a person It has to be specifically mentioned, and it should come during in investigation that there was a promise to give an undue advantage with the intention to induce the public servant to perform improperly a public duty, or to reward such public servant for improper performance of public duty. If a public duty is performed improperly, or the performance of a public servant is not proper, it cannot be presumed that such action was because he was bribed. There cannot be a presumption. Full stop. As mentioned earlier, after going through the entire record, I find that prosecution has not brought any material to suggest which would attract the offence under Section 8 of the Prevention of Corruption Act. Merely on presumption, the aforesaid section has been mentioned. Full stop. Next paragraph. Further, from the impugned order, I find that the Special Judge ACB Ranchi without any material on record became prejudiced by the nature of allegations which has been leveled. The Special Judge CBI did not even whispered in his impugned order as to which document is forged to conclude that there are materials to frame charge under Section 467, 468, 471 of the Indian Penal Code. Full stop.
Only there is violation of CNT Act is there, Your Lordship.
So that will attract a criminal offence. The Special Judge has concluded that there is a violation of the CNT Act. Even that be so, that violation of a CNT Act will not attract 467, 468, 471, 420 of the IPC, nor the provision of Section 8 of the Prevention of Corruption Act. Next paragraph. Thus, from what has been held above, I find there are no materials to frame charge against this petitioner under Section 467, 468, 471, 420, read with 120B of the Indian Penal Code, and Section 8 of the Prevention of Corruption Act. The ACB, the Special Judge ACB has wrongly concluded. The conclusion reached by the ACB is absolutely erroneous and is without any factual backing. Thus, these impugned order dated 26/2017, passed in so-and-so by so-and-so, is washed and set aside. Full stop. Consequently, the petitioners are discharged from case. This application stands allowed.
Obliged.
Obliged.
Yes.
Serial number 37 with serial number 38 with serial number 39. Criminal division 684 of 80 with criminal division 708 of 80 with criminal division 773 of 80. Mr. Samir for petitioner in first case, Mr. Hemant Kumar Sekarwar for petitioner in second case, Mr. Kumar Harsh for petitioner.
My lords, in item number 39, I'm appearing, my lords. I'm seeking permission to withdraw this case, my lords.
Kumar Harsh.
Yes, my lords.
Seeks permission to withdraw this case. So criminal division 733 of 2018 is dismissed as withdrawn.
Much obliged.
Yes, Mr. Samir Saurav.
My lord, on the last date directed the council of the CBI, by order dated lordship 7/12/2021, to go through the case diary to show the conspiracy, lordship, as they have, as on the last, my lord of gone through the charge sheet, entire charge sheet.
Where is Mr. Hemant Shikarwar in the other case? Yes.
Yes.
Mr. Hemant Shikarwar is the petitioner in another case. Where is he? I'll hear you. I'll hear the CBI. Then no one will appear in the other case.
Everybody has to appeal, lordship.
These cases cannot be heard in a piecemeal way.
No, lordship. No. So next Friday, this I will inform him for next. This may be taken up on next Friday, lordship.
Yes, inform him. Tell him to appear. Mr. Hemant Shikarwar is absent. Full stop.
My lord, if the case diary is available with your lordship, I'll just point out document number 5 and 6, DW, mentioned in the charge sheet. 2 documents only. So your lordship doesn't have to go through the entire diary. Only document number 5 and 6.
Next Friday.
My lord.
Mr. Hemant Shikarwar is absent, though the other councils are present. Full stop. Since Hemant Shikarwar is a petitioner in the connected case, in one of the cases, this case is and in his absence, the entire matter cannot be heard. Also, this case is adjourned for 1 week. This case after 1 week.
Lordship, next week, बहुत देर से आता है.
Next week, there is a batch cases which has been kept for next week.
Then next Friday, lordship.
1 week. I've said 1 week.
Obliged.
After 1 week.
Lord, I'm extremely sorry I was not there in item number 15 to 18. I was in another court, perhaps.
Case number?
Item number 15 to 18, your lordship. That was
After 2 weeks.
After 2 weeks.
My lord. Usme the status is there, my lord. The 3 witnesses have been examined in one case and another 4 have been examined.
How many left?
Left, there are more than 10 left, but due to the pandemic, it has been stopped. But
now it has started.
Yes, my lord. Yes.
It has started physically.
Yes, my lord. Correct.
Serial number 40, CRP number 920 of 18, Mr. Rajesh Kumar, Mr. Sundar Mujumdar, Mr. Vikas Kumar, Ms. Madhulika Das Gupta for the petitioner.
Your lordship, I am appearing in this case, your lordship. Although in this, there are 2 petitioners. The petitioner have prayed for quashing of the cognizance order, your lordship. The 10th of August 2011, your lordship. But on the last day, your lordship is pleased to call for this.
Charge has been framed.
Charge has been.
You have filed a discharge application which was dismissed.
Yes, your lordship.
So then, why should I interfere in this cognizance order?
I'll file the amendment application.
No, sorry, I will not allow you.
Actually,
your discharge application is dismissed.
Yes, discharge application.
Heard the counsel for the petitioner, heard the counsel for the state.
Then your lordship, I am permitted to withdraw.
I am appearing in this case, your lordship.
Mrs. Majumdar, appearing on behalf of the petitioner, submits that this that in this application she has prayed to quash the order taking cognizance in case number so and so, dated so and so, in case number so and so. Next paragraph, she submits that charge has already been framed in this case, and as the application for discharge was dismissed. Mrs. Majumdar?
Yes, Your Lordship.
Dismissed. Full stop. Next paragraph. Considering the aforesaid submission, I find that aforesaid submission, since the discharge application of the petitioner was dismissed, it will not be proper to interfere with the order taking cognizance. Have you challenged the discharge application?
Your Lordship, the information which I gathered, although they said that the discharge application was rejected, but I have not filed
But have you challenged that rejection order
before this honorable court? I am not the lawyer, Your Lordship, before this honorable court.
This application is disposed of.
Okay.
Number 41, PRP number 14480, Mr. Abhay Pandey,
Petitioner pays for cancellation of bail, bail allowed on page 11, madam. The OP number is considering the fact that he has granted he is on bail, police bail, despite
What is the stage of trial? What is the stage of trial?
the stage was called for by an earlier man.
Yes.
Stage was called for.
Whatever the trial stage was called for. It is dispute between husband and wife. It is the bail of wife.
No. Okay. It's evidence before charge. So you let the trial be concluded.
She has concealed the fact that she was on police bail.
Because this application has been filed. This application has been filed by the petitioner, who happens to be the husband, to cancel the bail of the wife, which was granted by this court in BA number 12. Next one. Counsel for the petitioner submits that the wife had, while obtaining anticipatory bail, has suppressed the fact that he was on police bail. This is the ground for cancelling the bail.
That was not the police bail. My submission is that was not the police bail. We appeared before the police, that we will appear before the court.
Oh, okay. This is the ground for seeking cancellation of the bail. Also, next one.
Para 6, madam, she was on police bail, madam.
Yes. Para 6 only, it has been stated that I will appear before the court.
The counsel for the petitioner, the counsel for the wife, submitted that, in fact, when the FIR was lodged,
complaint case, when the bailable warrant was issued,
it submitted that the case was instituted on a complaint, and when the bailable warrant was issued, they appeared before the police and submitted that they will appear before the court. He further submitted that since the offences were non-bailable in nature, they approached the court by filing an anticipatory bail. Full stop. He submitted further that after the anticipatory bail was granted, they surrendered before the court and their bail bond was accepted. Full stop. He submits that ultimately, by virtue of the order, they surrendered before the court. Full stop. Next paragraph. Considering the submission of the parties, I find that the dispute is between the husband and the wife. Full stop. I had called for a report from the court below about the status, and the court had reported that before the court is recording evidence before charge. Full stop. In the report, there is nothing to suggest that the wife has misused the privilege of bail. Full stop. Further, the trial is continuing. Full stop. Considering the fact that the wife has not misused the privilege of bail and is cooperating with the trial, I'm not inclined to cancel the bail which has been already granted to the wife. This application is thus dismissed. Full stop. Next paragraph here. The trial court is directed to take up the trial and try to conclude the same at the earliest.
Obliged.
Stop. Yes, you will cooperate, Mr. Dinesh Kumar, your client. Counsel for the wife submits that his client will cooperate with the trial court in conclusion of the trial. Next paragraph.
Serial number 42, criminal litigation 1572 of 18, Mr. K.S. Nanda.
But the trial has in progress, my lord, significantly progressed. Therefore, I may be permitted to withdraw this application.
Mr. K.S. Nanda submits that the trial has significantly progressed. Thus, he wants to withdraw this application.
The appropriate stage में
What stage क्या होगा? He submits that he may be allowed to raise all the points while finally arguing in the trial. In his argument in the trial, full stop. They are allowed with the aforesaid liberty. This case is dismissed.
My lord, I am appearing for CBI, my lord.
Give your slip. The name will be typed in the order sheet.
Serial number 43, PRP number 4168 of 18, Mr. Chandran Kumar, Mr. Vijay Kumar.
Yes, my lord, I am appearing in this case, my lord. My lord, in this case, your lordship will find, my lord, the petitioner carrying the cognizance of all subsequent proceeding, my lord, with respect to the offence under section 420, 467, 468, 471, 120, 109, 201, 423, and 13(1)(d) of the PCR. My lord, lordship, kindly see, my lord, the charge sheet at page 129, my lord.
129.
Lordship.
Yes.
My lord, second paragraph, type copy, my lord, your lordship will come to, my lord.
Where is the type copy?
My lord, it is just before the impugn order at page 1.
Let me go through this. Yes. You read. You read the charge sheet.
Lordship. My lord, starts, my lord, page 128, my lord.
Yes.
है कि रांची जिला अंतर्गत नामकोम अंचल के मौजा बरगावा के खाता संख्या 87 प्लॉट नंबर 4, 5 और 6 के कुल रकबा 48.66 एकड़ भूमि जो खतियान में गैर मजरूआ मालिक दर्ज की गई है, जिसमें से 41 एकड़ भूमि को प्राथमिकी के अभियुक्तों द्वारा साजिश रचकर गलत तरीके से अपने पद का दुरुपयोग करते हुए सुनिश्चित सरकार का आर्थिक क्षति पहुंचाने के उद्देश्य से प्राथमिकी अभियुक्तों के विरुद्ध उक्त आरोपों के आलोक में यह कांड अंकित किया गया है। वादी तथा गवाहों के बयान, घटनास्थल का निरीक्षण, अनुसंधान एवं प्राप्त दस्तावेजों में से एवं पर्यवेक्षण से यह कांड प्राथमिकी के सभी नामजद अभियुक्तों यूके शरण, कुमार राणा अवधेश, सुबोध कुमार गुप्ता, दिनेश कुमार द पिटिशनर, पंचदेव सिंह, बाबूलाल सिंह, लक्ष्मी देवी, श्रीमती सुदामा देवी, उर्मिला देवी, सिमलो देवी, हरिचरण साहू, श्रीमती भगवती देवी, द्वारिका प्रसाद मोदी, देवकीनंदन मोदी, ठाकुर जगदीश नारायण सिंह वगैरह के विरुद्ध 420 स्वयं के अंतर्गत प्राथमिकी के सभी अभियुक्त के विरुद्ध कांड सत्य प्रतीत होता है और इनके विरुद्ध उक्त धारा में आरोप पत्र समर्पित करने का पर्याप्त साक्ष्य उपलब्ध है। Thereafter it is being said, my lord, 10 persons, my lord, has been died, my lord. The up to 10, my lord. Then, my lord, Kumar Rana Avdesh Singh urf Rana Avdesh.
Yes, Kumar Rana Avdesh Singh. Yes.
कुमार राणा अवधेश सिंह, अली राणा अवधेश, सुबोध कुमार गुप्ता, सुदामा देवी, पंचदेव सिंह के विरुद्ध आरोप पत्र संख्या स्वयं दिनांक स्वयं के आलोक में धारा स्वयं के अंतर्गत किया जा चुका है। इस कांड के प्राथमिकी अभियुक्त दिनेश कुमार के विरुद्ध अभियोजन स्वीकृतादेश के प्रताप स्वयं के अभियोजन स्वीकृति प्राप्त हो चुका है। अतः मतलब then my lord, so far as the petitioner is concerned, the charge sheet has been submitted. Now your lordship, so far as the accused persons Rana Avdesh Singh, Subodh Kumar Gupta, Sudama Devi, Panchdev Singh, my lord, the case has already been quashed, my lord, by this honorable court, my lord. The copy of Sudama Devi is annexed page 131, my lord.
131.
Yes, in this case itself, my lord.
131. Yes.
Yes, my lord. So far as Sudama Devi's order is this, my lord. So far as the other accused persons is concerned, my lord, I have filed a supplementary affidavit, my lord, with respect to Panchdev Singh, my lord. Rana Adesh Kumar, my lord.
Who are you? What is your status?
I was posted as circuit officer, my lord. And
What
so
is-
land in question is,
What is the allegation attributed to you?
yes, my lord, that I'm coming to that. Just I'm pointing out your lordship, my lord, so far as the land which has been mentioned, plot number 4, 5 and 6 of Khata number 47 of Badgaon, my lord, that has been challenged before this honorable court by Sudama Devi, my lord, Lakshmi Devi, and the honorable high court has set aside the order of the commissioner, my lord, with respect to that part, and it has been confirmed in the LPA has been dismissed, my lord. I have forwarded the reference, my lord, that is 2003.
Where is the writ order?
Pardon, lord.
Where is the writ order?
Writ order, my lord, reported in 2003, volume 2, JCR, page 489, my lord.
No. You bring on record the writ and the LP order.
I'll file it, my lord. I will file it. I have sent the reference, my lord, so far as the reported, it was reported, therefore I have not.
It was reported. But you have to say that it is my case, in this case, this has been done in this case.
Yes, my lord, that I have to.
So reporting a judgment which you are referring as a precedence or for some purpose, you need not file it. But this is a document, which is an exhibit in your case.
That can be.
When you cite some case as a reference, the matter is something. But when you cite a judgment, as an evidence in your favor,
then
that is to be marked as an evidence.
That can be.
Over here, in this case, it will be an annexure by way of an affidavit.
I'll do it, my lord. I'll do it.
Bring it on record.
I'll do it.
Because they may record saying that no, this is the fact, this case was different from, this fact is different from them.
No, there, my lord, otherwise I would not have submitted, my lord.
Yes. 2 weeks time is granted to bring on record by filing an affidavit the judgment passed in the writ application and which has been upheld in the latest patent appeal.
LPA, my lord.
LPA.
My name may appear in the cause list, Your Lordship.
Mrs. Priya Shresht appear in the cause list.
Serial 44, Civil Division 11 of 19, Mr. Rahul Sabu, Mr. Gaurang Fidodia, Mr. Amitesh Kumar Kese, Mr. Jagdish.
Your Lordship, in this case, I am appearing on behalf of the petitioner. Your Lordship, in this case, Lords, Mr. Jitendra Kumar Singh is the arguing counsel, my lord. He will be arguing, my lord. On his behalf, I'm praying for 2 weeks' time, my lord, in this case.
Where is he?
My lord, he is in some facility, but he was not understanding. He had requested my lords to grant 2 weeks' time in this matter, my lord. Because and next week also he won't be available, my lord. That is why.
Sought to adjourn the case on behalf of Mr. Jitendra Singh.
Obliged.
Serial number 45, CRP number 98 of 19, Mr. Nitesh Kumar, for the petitioner.
No one appears, adjourned for 3 weeks.
Earlier also they have taken so many time, my lord.
Serial number 46.
Nothing can be done. No one is appearing. There's a self-restraint order that we will not dismiss any case for default.
My lord, no, I am there, my lord. I would like to apply to lordship. My lord, I am there in the morning itself, my lord.
Oh, you are here? Yes.
Yes, my lord. Please, my lord.
Argue.
My lord, 2-3 points, my lord. I am praying to you, lordship, to consider, my lord. I am not named in the FIR. That is, my lord, my first and foremost point, my lord. There is no allegation or role assigned to me in 164 statement, my lord. So kindly, my lord, see the FIR first. And, my lord, what is the allegation against me, my lord? That is the very foundation of the case, my lord. It is the total allegation is unfounded, my lord.
What is your
see, my
prayer?
lord. Please, my lord.
What is your prayer?
My prayer is, my lord, that I should be discharged. Because there is no allegation, no offense is made out, my lord.
What is the
Under
case number?
article-
What is the case number, Mr. Counsel?
It is the case number, my lord,
CRMP?
321 of 2019, my lord. 321 of 2019, my lord. Item 46. Whether is there, my lord.
I'm in 45. I'm in 45, Mr. Counsel.
Oh, I am so sorry.
My lord, sorry. My lord, sorry. We are in 46. My lord. Sorry.
45. Who is in 45?
Mr. Nitesh Kumar.
Okay, no one appears, Nitesh Kumar.
Please, my lord. I would like to repeat what I have said, my lord.
Just a minute.
I have not been named in the FIR, my lord.
Serial number 46.
Please, my lord, I am audible to you. I am audible to you, Lordship, my lord.
46. Yes.
My lord, with great respect, my lord, I have 3 points to converse before your lordship, my lord, for kind consideration, my lord. Number one, my lord, I am not named in the FIR, my lord.
Yes.
There is no allegation against me.
Yes.
And my lord, learned trial court, my lord, in a casual manner, dismiss my discharge application. But my lord, the vital thing against me is, my lord, the Supreme Court judgment. So, my lord, I would like to bring to your lordship, my lord, those pages of the Supreme Court judgment. And then, my lord, on the last occasion, on 17th December, my lord, your lordship has said me that you bring those judgments because, my lord, in some of the items today, your lordship has said that is not the law laid down by the Honorable Supreme Court. So, my lord, my premises is that, my lord. In Article 141, my lord, if some law was not laid down, the pleadings are not proper, my lord. If pleading was not adjudicated, that is not a law, my lord. So, my respectful submission, my lord, that whatever has been said, it is for the other accused, my lord. Since there is no allegation against me, my lord, I am not named the FIR, my lord. I should be discharged. So, in some substance, my lord, this is my case. So, I seek your lordship permission, my lord, firstly to read the FIR, my lord. Then I will bring your lordship to the Supreme Court judgment, my lord. And then, my lord, I will show to your lordship 3-4 precedent in which Honorable Supreme Court has said, my lord, that in 141, if something is dismissed in limine, or even if it is not a judgment at all, if it is not a judgment at all, my lord, that London trial court should have adhered to these issues, my lord, on the factual metrics, my lord. They have simply dismissed my matter, and that has resulted in discourage of justice, my lord, with greatest sense of respect to my lords. So, my lord, kindly see the FIR first. It is, I seek your lordship permission to read it, my lord.
Who is for the opposite party?
My lord, I am appearing for CBI, my lord.
Okay. Yes.
Please, my lord.
Yes.
My lord, it is at page 37, my lord, 37.
Page 37.
37.
Yes.
Please, my lord. My lord, information has been received from a reliable source to the effect that Dr. Pradeep Kumar, IAS, while functioning as the Secretary Health Department, Government of Jharkhand, during the period between 2008 and 2009, entered into a criminal conspiracy with Dr. Vijay Shankar Singh, State RCH Officer, Namkum Ranchi, with some unknown official of the Health Department, as well as some private person, namely some Sri Shyamal Chakravarti, Dharmendra Kumar Dheeraj, the partner of this and this, my lord, Anup Chakravarti, this and this, in furtherance of said criminal conspiracy, thereby abusing their respective official position as public servant, fraudulently and dishonestly purchased medicine, medical equipment, sundry items are used in the hospital from 19 supplier.
Just a minute, Mr. Consul, just a minute. Where are the area accused? I'll not hear this. I'll not hear this. I'll not hear this. I can't hear this.
You cannot hear it.
No.
Am I audible to your lordship?
Yes, yes.
No?
Not hear means I can't hear this matter.
Oh, that's correct, my lord. That's the lordship prerogative, my lord. That I cannot say anything, my lord.
because this is for the first time we are going through these documents, because earlier only a time was sought for, which was granted. And after going through the FIR, I think that most probably it will not be proper to hear. Let this case go on my list to be listed before the appropriate bench in which I am not a member.
Deeply available.
I'll put in your appearance. Your name?
My name is Prakash Kumar Singh Tomar, my lord. I am from Supreme Court.
Yes.
Yes,
Mr. Prakash Kumar Singh. Learned Counsel argues after that.
Hello.
Going through the record, After going through the record, this court feels that it will not be appropriate for this court to hear this matter. Place this case before appropriate bench.
Along with Vikas Pandey, my lord.
Yes, along with Mr. Vikas Pandey, assisted by Mr. Vikas Pandey.
Deeply available.
Sorry to keep you waiting for such a long time for this order.
No, my lord. My lord, I was fortunate enough when your lordship was hearing other matter. I was hopeful that your lordship have met my 2 points. You are telling to some lawyer, my lord, you just dictated the order, so I was hopeful, my lord. I've got a good bench. But anyway, I will try my luck, my lord. Whenever it will happen, my lord, I will before your lordship. No problem.
Yes, next.
Serial number 47, Single Division 360 of 19. This is the single Ravindar, Mr. Vikas Kumar.
Your Lordship, in this case, I am appearing in this case, Your Lordship. In this case, I have filed one interlocutory application for clarification of the order dated 7th of January 2020, Your Lordship, passed by Your Lordship, 17th of January 2020, passed by Your Lordship, Your Lordship.
Yes.
In this case, Your Lordship, if you just see the order dated 17th of January 2020, Your Lordship.
Yes.
Issue notice to the opposite party under register covered with AD as well ordinary process for
Who are
which
you?
I am the husband, Your Lordship. In this case, I have challenged the maintenance order where I was only for the quantum of maintenance, 15,000 to the wife and 3,000 to a child, Your Lordship. In
Yes.
that, Your Lordship is pleased to pass this order. List this case after receipt of the service report. It is made clear that the distance warrant will not give effect to. The petition is directed to deposit monthly maintenance before the learned court below, which can be disbursed after any order is passed by this court, Your Lordship. Now, this petition is regularly paying the monthly maintenance. That is not in dispute, Your Lordship.
Then what is in dispute?
The dispute is, Your Lordship, I've just annexed the entire order sheet with my interlocutory application, Your Lordship. If we just...
Your I is for what purpose?
I is for clarification of the order dated 17th of January, Your Lordship. Because again, I have been asked to deposit 1,08,000, Your Lordship. The areas of maintenance, although regularly paying my current maintenance, but the learning... Yes.
The areas should also be paid.
Your Lordship, areas, that what I have annexed in my affidavit, Your Lordship. She says that she has been expelled from the house. She's staying in that house only.
Mrs. Majumdar, thank you. You have brought to the notice of this court that inadvertently the areas was not mentioned there.
No, Your Lordship, to that I'm coming into the merit of the case, Your Lordship. No, Your Lordship, she's coming in my parents.
What I had forgotten to incorporate in the order, thank you that at your instance it will be now be incorporated.
No, Your Lordship, 1 minute dekha jaye, Your Lordship.
The IA.
My lordship, I am appearing on behalf of the respondent. My lordship. Kindly allow the respondent to withdraw the entire maintenance amount. My lordship.
First argue the case.
Your Lordship, 1 minute.
This entire case can be disposed of. Both the parties have appeared.
Yes,
Yes.
sir.
Are you ready for final hearing?
No, my lordship. Today I am not prepared. My lordship. I am concerned with the IA application only, my lordship.
So next week,
Kindly allow me time, my lordship.
Next week,
my lordship.
I'm keeping it on next week. Get ready for final disposal of
Yes,
this.
sir. Next
My
week.
lordship, time being, my lordship, kindly allow the respondent to withdraw, my lordship.
Next week, final order हो
I'll not
जाएगा.
allow you. I'll not allow you.
1 week का बात है, next Friday.
This order was passed just you.
My lordship, respondent have no any other sources.
Secure your appearance. This order was passed to secure your appearance. And you knew very well when I will direct them to deposit the money and not allow you to withdraw, you will first come and appear immediately. The purpose of this is, sir, that you have appeared now, the next final disposal. This case under the heading for final disposal next week on the request of the parties. It is government will be granted.
Oblige.
Leftover cases, some of the dates.
Next week, my lord.
Next week or week after next, I'll see to it. What appointments we have kept next week? What is the board for next week? Let's see.
Obliged.
Yes.
Obliged, my lord. Obliged, my lord.
Obliged, my lord.